After hearing the learned counsel for the parties and going through the documents appended with these writ petitions as well as the report submitted on behalf of respondents number 1 and 2, it has been noticed by me that the matter in hand has borne out from some civil contracts between the petitioner companies and respondents number 2 to 4, regarding which civil suits for specific performance of contracts instituted by the petitioner companies are also pending before the learned civil court. Under the garb of above said contract, a hefty amount had been embezzled by the petitioner companies with the active connivance of some officers from Ministry of Social Welfare and Special Education, Islamabad, and that is why the FIA has come to the field to thrash out the fraud committed in these cases. A plain reading of the petitions as well as the reply submitted on behalf of respondent number 1 and 2 reveals that certain factual controversies are involved in these cases which cannot be resolved by this court while sitting in writ jurisdiction under Article 199 of the Constitution. The reply further reveals that the petitioner companies have made some concealment during the bidding process. One of the members of the procurement committee has disowned joining of the bidding opening proceedings, and some members have denied making signatures over comparative statements. It has also revealed during the inquiry proceedings that the petitioner companies had been obtaining amount without submitting any bank guarantee according to the rules policy. In this view of the matter, the question whether the bidding process had rightly been adopted by the procurement committee in its true spirit or not, as also the question whether the petitioner companies have acted in the manner and mode formulated by the parties at the time of contracts, or the petitioner companies have obtained money from deceitful manners or not, are questions which need recording of evidence, and the same exercise cannot be undertaken in the present summary procedure by this court, especially in the circumstances when the matter is already sub judice in a civil court. Even otherwise, this court would not like to jump into the factual controversy between the parties and comment upon the same at such a premature stage, which act, of course, will prejudice the cases before the learned civil courts. After finalizing the inquiry proceedings, the inquiry agency has already submitted its report. Thus, this court is slow in interfering into the matter at such a stage of these cases. Admittedly,